All right. Hi, this is Bruce Hammer. If you are joining this video now, we are about 3 minutes away from starting. So if you're looking at the video, just advance ahead until we actually start the class. This will be on negligence, torts, and how they're associated with the real estate industry and real estate agents. So just bear with me until we get started. Hi, Anna.
Hi, Bruce. How are you?
No worries. We got about 2 minutes before we're going to get started.
Okay.
Hey, Anna.
Yeah.
Just curious. When you are, on this Zoom call, are you just seeing my image?
Yes.
Okay. All right. That's fine in this case. Hi, Teresa. I'm going to wait about 1 more minute before I get started because Leslie assured me that we'd have a bunch of people on this class today, and so far I only see two of you. All righty. There's only two of you, but I think we're going to get started. Um, in this is a new class. I haven't taught this before. I just put it together over the last week. And there's some areas that are still a little bit rough. So I'm not going to have a handout for you yet. By the time I do the class again, I will have a handout for you to take with you. Um, but there seems to be a lot of, um, let's just say, confusion or lack of knowledge by real estate agents as to how they can get in trouble with their clients, with their transactions, in regards to negligence. So what I want to do is kind of take some of the mystery away from that. I'm going to spend some time. I'm going to go through some of the more boring legalistic stuff about what is negligence, what are torts, and things like that. And then in between this, I'm going to intersperse some actual examples as to how that might pertain to somebody in the real estate business. So this is a little bit different than what we've done in the past, at least what you guys have experienced in the past, because the courses or the classes that I've been doing with you are ones that I've done over and over since I put them together. This is brand new. And so, when we're done, um, I would ask you to shoot me an email and let me know, did you get anything out of it? Is it something that will help you? Was it too far in the weeds in terms of the law, or was it just enough? Give me some honest feedback. I assure you there is nothing I will take personally. I'm an old Marine, I'm an ex-cop, I have big shoulders, so you won't offend me. Um, but with that being said, I'm going to go ahead and get going here. As I said, this is to talk about some aspects of tort law, which includes negligence, and then kind of go into a deep dive as to how that can affect you in a real estate transaction. Now, um, the stuff I'm going to talk about here, this is stuff that if you go to law school, they take an entire year to teach this topic. And that's a year of you going through 100 pages of cases per week, sometimes 200 pages, and then slicing and dicing and dissecting all of these cases that go into making up what is in some respects very old case law. So first of all, what is a tort? What is negligence? Why is it important to understand these terms? And how do these confusing terms play into your practice as a real estate agent? Well, first of all, let's just talk about torts in general. A tort is it's kind of code for a civil wrong. You see on TV all the time, you see people, oh, John was arrested for drunk driving, or, this old guy was, he battered his wife and he's being prosecuted. Those are criminal wrongs. When you're talking about tort, you're talking about a civil wrong, something that there can be civil remedies for. And so torts generally fall into three categories. You have intentional torts, and common intentional torts that you might have heard about. And I want to distinguish the first two here are battery and assault. Those two are actually individual civil torts. There are identical named criminal violations that you'll find in the penal code. So those are ones where there's an example. You can have a tort of battery or assault, and you can have a criminal charge of battery or assault. You can have another tort would be false imprisonment, or trespass to land, or trespass to chattels. Those two in particular, although they aren't negligence, those two in particular have affected real estate agents in their transactions. Trespass to land, great example. You list a property for an investor owner. There's a tenant in the property. The tenant and the property owner or seller aren't cooperating with each other. And the tenant doesn't give permission for the property owner or their agent to go onto that property. If you access that property to, for example, put a signpost in the yard, put a lockbox on the door, you have committed, in criminal law, you've committed trespass to land. In civil law, you've committed the tort, the intentional tort of trespass to land, and you can be sued for that, right? One of the key things with intentional torts is there has to be intent. It's in the name. So when you take that step to go onto the land, your state of mind is you intended to step onto the property, not you intended to violate that tenant's rights. And that's an important distinction that can have an impact on whether somebody could get a judgment against you or not. Other intentional torts that maybe aren't so prevalent in the real estate industry might be intentional infliction of emotional distress, trespass to chattels. Do any of you know what a chattel is? No? How about you, Leslie? Do you know what a chattel is?
Actually, no, I'm here to learn today. I don't know what a chattel is. What is a chattel?
Chattel is a piece of personal property.
Oh, good to know.
So if you're showing property, you have a license that's granted by that seller to go into their property as a real estate professional with your client. But if you or your client moves a piece of furniture in their house or goes into a cabinet and moves stuff around so you can look around, or goes into a closet and moves boxes, that under the law would be considered an intentional tort, and the tort would be trespass to chattels. Okay, so I'm going to tell you a lot of things, and if you just focus on half of the stuff I tell you, you're probably going to get really fearful about being in this business. So what I'm going to tell you is, stuff that you also have to think about the inverse. When you take a client into somebody's house, make sure you're not moving stuff around. When you go there to do a home inspection, you're meeting the home inspector out there. Home inspectors won't normally move furniture and stuff. Make sure you don't either. We've actually had a case in this office where on a final walkthrough, somebody pulled portraits or artwork off of a wall to see the size of the hole that was going to be left behind. They happened to be valuable artworks. And there, is a potential dispute about, what are you doing touching my belongings? Okay, that's trespass to chattel. So, I'm gonna talk about some of the areas you can get into trouble, but I'll also talk about ways that you can avoid getting into trouble. If something is an intentional tort, it cannot also be negligence. And I'm going to tell you right now, the reason I'm going to distinguish the two, and the reason this is important to you guys, is because if you commit professional negligence, you are covered under our errors and omissions policy. That's what an E&O policy, also called professional liability insurance, that's the whole purpose of a E&O policy, is to protect you and to protect us in the event you are unfortunately negligent in how you handle a transaction. What E&O policies exclude coverage for are intentional torts. If you assault somebody, if you commit battery upon somebody, if you trespass on land or chattels, if you commit a fraud, things like that, those aren't going to be covered by your E&O insurance. Okay. Now, most of us, when I teach my fair housing class, I always give the statement, most of us don't wake up in the morning and decide we're going to, discriminate against somebody. It's not something that we make a plan to do. And we don't make a plan to commit intentional torts either. But since it's not something that is covered under our E&O, you also need to think about these things, and you need to learn what you don't know, and that's what we're trying to do here. Now, within intentional torts, there is a subcategory of fraud. And when you hear that word fraud, and it can be in several different contexts, you should be thinking in your head, ding, 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 because that's a big one. And why is it a big one? Because number one, the statute of limitations for a plaintiff's attorney to bring an allegation of fraud is a lot longer than the statute of limitations on a negligence issue. So you give the attorneys more leeway. Plus, the penalties for fraud can be much more severe when it comes to remedies. So I'm going to give you some examples of fraud just so you have them in your back pocket and you can be aware of them. And then we'll move on from there. So the first one I wanted to bring to your attention is something that we call actionable deceit. And that's actually, it's ingrained in our civil code, section 1709. Now, whenever you talk about one of these types of torts, if a plaintiff were to take you into court, and this goes for criminal charges as well as civil tort charges or complaints. And I'll give you an example. In California, every criminal code in the penal code has what's called elements. And the elements, for example, of a burglary, you have number one, the entry, number two, into a building or structure, number three, with the intent to commit grand or petty theft, or four, or a felony. Now, what does that mean? That means that if actually, let me see if I can give you a realtor example or a real estate agent example. You have a listing to a house, and you know that your client is going to be away on vacation for a week. And so you go to that property at night and you use your lockbox key to open the door, and you enter, you pass that threshold, and you have the intent to go steal one or two pieces of raw diamonds that you know that your seller client is keeping in a secure location in their closet. You've entered a building or structure with the intent to commit grand or petty theft or any felony. You are guilty of a burglary. Now, that's the criminal version of this. If you go back, and the point I was trying to make with all that, I didn't intend to get so far into the weeds. The point I was trying to make is everything has elements that have to be met. So for an intentional tort, for actionable deceit, the elements are that there be a misrepresentation. So that would be either a false representation, a concealment, or a non-disclosure. The terms false representation, concealment, non-disclosure, those should be things that we're thinking about when we're working with sellers, because those are the type of things that can come up that can lead to an allegation of fraud on your part or on the seller's part. So the first one is the first element, you have to have a misrepresentation, which is a false representation, a concealment or non-disclosure. The second element would be you have to have knowledge of that falsity. Now, under the law, that's known as scienter. The third element, you have to have an intent to defraud or induce reliance on that. And then you have to have justifiable reliance, meaning the buyer, let's just say it's a seller representation or whatever, or you're representing and a buyer buys the property. The buyer has to believe that what you're saying is true if you're making a representation, and it has to result in their damages. If all of those elements are there, then the plaintiff's attorney has proven their case for actionable deceit. There's also the tort of intentional misrepresentation. Those elements would be something like, the elements are, one, the defendant represents to another that a fact was true. the representation was actually false, the defendant knew the representation was false, or it was reckless about its truth. What does that mean? Well, maybe the defendant wasn't sure that it was false, but the defendant kind of hit his head in the sands and decided not to go do any further research to confirm that it was either false or it wasn't false. That would make it reckless about its truth. And then you have this other one here, which comes up quite a bit in real estate contracts, and that's fraud in contract formation. Those elements would be the defendant represented to the plaintiff that a fact was true, the defendant's representation was false, he knew it was false when he or she made it, and that he or she made it recklessly and without regard for the truth. The defendant intended the plaintiff to rely on the representation, and the plaintiff reasonably did rely on the representation, and the plaintiff was harmed. You can see there's a lot of stuff that attorneys have to prove in order to make a case against you. With that in mind, what we want you to think about in your day-to-day practices is try not to make it easy for them to do that proof or to make their case. And we'll give you some tips. I'll give you some tips in a little bit to help you avoid doing that. And then you have negligent torts, which is kind of the majority of what we're going to talk about. And I'll talk about that in a second. And then the last one is strict liability torts. We don't have to worry too much about those. Those would be like abnormally dangerous activities, or somebody that owns dangerous animals, or product liability issues. Those are what we call strict liability torts. And kind of the best example of that would be, if you're transporting a truckload of TNT across the country and that TNT explodes, it doesn't matter. Nothing else that happens matters. It doesn't matter if somebody else crashed into your vehicle. You are strictly liable just because you were transporting it. Period. End of story. So now we're going to get into negligence specifically. Before we move on to negligence, I want to stop and ask, any questions at this point so far?
Yeah, can the client be held liable for these things as well?
Absolutely.
Okay.
And Teresa, that's a great point, because normally what happens, if the buyer is suing, the buyer usually finds a reason to name the seller. And if the seller is suing, they usually find a reason to name the buyer, but they also most smart attorneys will start off by naming everybody. The buyer's attorney is going to name both brokerages. They're going to name the seller. The seller's attorney is going to name both brokerages, the agents, the buyer. They include everybody in, and that's done for a tactical legal reason to begin with. Under California Code of Civil Procedure, under federal civil procedure laws, if you fail to name somebody that you should have named when you file the suit, it's almost impossible to get them added in afterwards. So normally what they do is they start off, they name everybody, and then people will start petitioning to get released from that suit, or they'll settle and get released from that suit as they go down the journey. All right, negligence. This is a really meaty subject. I'm going to give you kind of a deep dive on the elements of a negligence action. And then I'm going to give you some examples as they pertain to real estate. Actually, I might intermix that as we go. But in general, negligence involves a person's duty of care. And in the terms of what you'll be working, it's the realtor's duty of care. So a person is negligent if they do something that a reasonably careful person would not do in the same situation, or if they fail to do something that a reasonably careful person would do in the same situation. Real estate professionals are negligent if they fail to use the skill and care that a reasonably careful real estate professional would have used in similar circumstances. Now, in a normal negligence action, just you as a person driving down the road, if you're speeding, then you are violating your duty of care to the public. But in a real estate situation, and I should say, when you are driving down the road and you are speeding, the standard that's used to determine if what you are doing is a breach of your duty to the public or a breach of your duty of care is they use an objective standard. And you'll hear this, in the law, you hear this constantly throughout many different aspects. And it's always that reasonable person standard. What would a reasonable person in the shoes of John have done? And it's known as an objective standard. So likewise, in negligence actions, because this is in the context of professional liability, a licensed real estate professional, then the reasonable standard is what would a reasonably careful real estate professional have done under similar circumstances. All right. Now, negligence, and you've probably heard me talk about this in other classes, requires a plaintiff to prove, again, elements, 4 elements. The 4 elements are duty, breach, causation, and damages. If you can't prove those 4 elements, with one exception, which I'll get to in a second, if you can't prove those 4 elements, you don't have a negligence case that you can win. Okay? Now, if we look into the first element, duty demonstrates the expectation to use reasonable care in regards to others. It's also a duty of care. For example, if you enter a retail store, the shopkeeper owes a duty of reasonable care to those who enter that store. If there's trip hazards on the floor, this duty of care has been breached. If a driver gets behind the wheel while drunk and puts others at risk, he's breached his duty of care. That's all duty is. In a real estate transaction, a simplistic example of an agent's duty of care would be for a buyer's agent to recommend their client get a home, roof, and sewer line inspection. Similarly, if you're representing a buyer and when you draft the RPA, say on a property where the MLS states that there's a well and a septic system, if you fail to add the form SWPI, which is the septic, well, property monument, and propane addendum, that would be a violation of your duty of care. Okay, you're a licensed professional, and you should know that this is kind of a standard thing that you should do in order to, number one, exercise your fiduciary duty that you owe your client. But that's a common thing that agents are supposed to know is, yeah, home inspections are a good thing. Yeah, if there's a well and a septic on the property, when you're negotiating the contract, not after it's ratified, when you're negotiating is when you want to determine who's going to pay for that well or that septic inspection, who's going to pay to uncover those lids before you get to the time when, okay, I'm ready to do my inspection. Where are the lids? Seller, I don't know. Okay. Then it starts ramping up the cost to your client. So you have violated your duty. Also, if you're listing, say, property X, and the seller says, I think it's worth Y, and you just go with that amount without running a CMA before you list the property. Say the property sells immediately and it was later determined to be worth 100,000 more than what you listed it for. This is both negligence as well as a breach of your fiduciary duty. Okay, which is why, if you notice, if you've seen our new transaction templates, we are now requiring CMAs on listings to be signed by the seller. Same thing on the buy side when you're buying a property. It's just one more thing to show that you have been looking after your client the way a licensed professional is supposed to. So that was the first element, duty of care. The second element is breach. Breach describes the wrongful conduct or unlawful act that violates a defendant's duty of care. For example, we talked a minute ago about the shopkeeper, and we discussed he doesn't regularly clean the floor, and a trip hazard results and a customer slips and falls. That is the shopkeeper's breach. So they now had a duty to keep the floor clean. They didn't clean it, and somebody slipped. That's the breach. Now, in a real estate transaction, as in the example we gave previously, the agent who doesn't recommend a buyer obtain a home, roof, sewer inspection has likely breached his or her duty of care. And that would be with the likely exception of like a new home build or something like that, where we're not really representing the buyers. And then, so that's the breach. Breach is pretty easy to handle. Then we have, and this is the tough one, causation. And I got to tell you, there is case law going back a couple hundred years when it talks about causation in a tort case. The way the law works is they say you have to have causation, meaning what caused the injury, who caused the injury, how the injury was caused. And the law breaks that down into actual and proximate. And I'm not going to get too far into the weeds on that because it's a pretty heady topic. But just know that actual cause is also known as cause in fact. It's the event that was the immediate and direct cause of an accident or incident, or damage in terms of a real estate transaction, damage to a seller or buyer. For example, while walking across the street, while a driver's car is stopped at a crosswalk at a red light, the car suddenly moves into the intersection and strikes a pedestrian. Well, the movement of that vehicle is the actual cause of the accident, right? Now, proximate cause. So we just talked about actual cause. Proximate cause can be the same or different from the actual cause. Proximate cause is also known as the legal cause, and that's referring to a primary cause or an incident that set everything into motion. So building upon the previous example we just gave, let's just say, for example, remember the car we just talked about that went into the intersection and struck the pedestrian? Well, let's just say, for example, that car was stopped at that red light, guy's pressing on his brake, he's not moving. And all of a sudden, a large truck comes up behind him speeding, and that truck hits the parked car and forces the parked car into the pedestrian. Well, then what you have is the truck would be the proximate cause of the pedestrian's injury, but the car that hit him would be the actual cause. Now, you have to be both actual and proximate cause in an action for negligence to be found in violation. So you can see where it gets a little heady. And then, and I'm not going to go into this too much further, but I do want to share with you, and this is an example of how these laws morph and change over the years. This modern view that I just spoke about, where they break causation down between actual and proximate cause, a lot of it stems from this very old case. And I think I told Leslie, I think maybe it was you, Leslie, I told about this case a few days ago. And this is a case they have taught in law school tort books now, going back probably 75, 80 years. The case is called Palsgraf versus Long Island Railroad, and it's a New York case, and it dates from 1928. And here's kind of the gist of it. I'm telling you this because A, it's kind of funny. Well, funny, not funny, but B, it gives you an idea of what kind of put this all into motion for the courts through years and years of case study to kind of bring us to where we're at today. So in Palsgraf, Mrs. Palsgraf, the plaintiff, was standing on a railroad platform purchasing a ticket when the train began to pull forward. There were two men that ran forward to try to catch that train. They're huffing and puffing, running down the ramp, trying to get to the open door. Standing in that doorway is a conductor ready to grab their arm and pull them on the train. Now, you can't imagine something like this happening today because everybody would be thinking, oh my God, somebody falls and gets hurt and they're going to sue us and this and that and the other. Well, back then, it happened all the time. Now, one of those men that were running for that train on the platform was carrying a wrapped cardboard box. Unbeknownst to anybody, that box was filled with fireworks. Now, as the conductor reaches down, grabs the guy's arm to pull him on board the moving train, the box drops to the ground and gets run over by the train's wheels. That results in an explosion. Now, the explosion itself didn't do a lot of damage. The train kept moving, all that good stuff. The problem was it set off a shock wave that went 150 yards down the platform and struck a gigantic scale that was right above Mrs. Palsgraf. That scale fell over, hit and injured Mrs. Palsgraf. I might have even killed her if my memory serves. Anyway, either the plaintiff or her plaintiff's family in the form of a plaintiff sued. And the whole gist of this opinion was determining how far removed something has to be before you can no longer say that they were the cause of a plaintiff's injuries. So if you look at that in a real estate transaction, I mean, and this is kind of, I'm horrible with making up examples on the fly, but let's just say, actually, this is not such a bad example. You're working with a buyer, and let's just say you've done 10 transactions over the last year. And every single one of those transactions, you have been the one to decide who's going to be the home inspector for that buyer. You've contacted the home inspector. You've made arrangements for to get them the buyer's credit card information. You set up the appointment. You meet them out there at the property. And let's just say in one case, that home inspector was unavailable. So the home inspector gets a colleague to come out and do that inspection. And the colleague, I'm gonna really change this up. And the colleague on the way out to the house is pulling onto the street and gets broadsided by a car. And that colleague, who's also a home inspector, sues the home inspector that hired him, sues the home buyer, sues the agent. Then the courts would have to determine what was the actual cause and the proximate cause of this whole scenario, because you can see it gets kind of convoluted. How many steps away from the original thing would result in that injury or should be attributable to that injury? So we're not going to get into all that. It's just way too confusing. In California, they use something a little easier called the substantial factor test, which we don't need to get into here. Now, what we do need to talk about, though, because this is really important if you're in real estate in California, there was a really important case in 1984. And I'm not going to call anybody out, but you've all heard the name of this case before. They teach it in real estate classes. You've heard me talk about it in some of my classes. Case is called Easton v. Strasburger, and it's from the California Appellate Court, 1984. And that is the primary case that deals with duty and breach. And but the court's analysis gives us an eye, not just into duty and breach, but to how to view proximate cause in a real estate transaction. Now, the case involved the purchase of a home by some buyers. The home had been built on landfill that had been improperly compacted. That caused landslides and foundation cracks. The sellers knew about the slides and the foundation problems, and they had taken some corrective action, but failed to disclose this to either broker. They didn't disclose it to anybody. The jury found that the defendants were negligent, including the broker, the sellers, and the builder. They assessed $197,000 in damages. Now, back in 1984, that was a lot more money than it is today. Now, the key to the broker's liability, and this was textual dictum, what they call, in the opinion that was written, was that the court analyzed the broker's duty to the buyer and found that the broker's duty includes a duty to disclose that which should be known, and the duty to conduct a reasonable inspection to discover the information that reasonably should be known. The court quoted the NAR Code of Ethics and determined that the broker, as a, quote, professional, must possess certain knowledge about the property he is selling, and that the broker has, quote, an affirmative duty to conduct a reasonably competent and diligent inspection of the residential property listed for sale, and to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. Now, that verbiage, that text out of this opinion, that was what our California state legislature used when they passed the civil code section requiring all agents to do a diligent visual inspection disclosure of our properties, whether we're representing the buyer or the seller. It was done to give added protection to the buyer because we are professionals, and it just requires us to state with our eyes the obvious things that we see that should be brought to the attention of a buyer. Now, the facts of Easton, and this is the reason that the court held the broker liable. They said that the broker was aware of certain red flags which indicated an erosion or settlement problem, and yet did not request that the buyer get any soil testing. So you put that together right there, and the broker agent breached their duty of care. Now, we all know from classes we've talked about with AVIDs and stuff, we don't have to do, we don't have to climb on roofs. We don't have to crawl under houses and get with the icky spiders and any of that crap. But we do have to walk around the house. And if you can see the roof from the curb, you have to look at it, make sure there's nothing unusual that you should see that you should make the buyer, aware of. And we'll go more into AVIDs in a second. I've got some examples on that. The last element for a negligence claim is damages. There has to be some damages. If you don't have damages, you don't have a negligence case. And that can be made up of a lot of things. Typical negligence case, you can have, cost of medical care. You can have lost wages, diminished earnings in the future. You can have pain and suffering. You can have damages to the property. Anything you have to spend, your time, money, emotional labor, due to someone else's negligence is referred to as damages. Now, in a real estate transaction, damages might be the cost of replacing a roof that was found after the close to be full of holes and was leaking. The agent didn't recommend the buyer obtain a roof inspection. Additional damages might be the cost of temporary housing, damage to personal property that got damaged when water leaked in, things like that. And you might be thinking, well, maybe they had homeowners insurance that could take care of that. Here's the reality of that logic. Hopefully, most likely, the person had homeowners insurance. But once that homeowners insurance company pays out their losses, they're going to come after you and the brokerage for damages. They're going to what's known as subrogate. They're going to try to collect to get made whole of the claim they had to pay due to your negligence. So, in this example, actually, this one is pretty true to form with the roof. We actually had a claim within our office. This one was more fraud than negligence, but an agent obtained a pre-listing roof inspection that basically said on it, quote unquote, roof is at the end of its useful life, cannot be repaired, needs to be replaced. The agent concealed that report from the seller, and once they got a buyer, the agent concealed that report from the buyer on the other side of the transaction. After it closed escrow, roof started leaking, damage started happening. Buyer calls a roofer out, and the roofer says, I already inspected this roof. It was ordered by such and such agent on such and such date. I gave them the report. Well, they got a smoking gun, and that is a case of fraud. That's real life. That happens. Okay. Now, wrapping up kind of the basic negligence, there's one topic that's really important to us, and it's made even more important because of the civil code statute that requires us to do an agent visual inspection disclosure. And that topic is what's known in the law as the doctrine of negligence per se. Have any of you heard of that before? No? Okay. Negligence per se is it's a doctrine codified. It's actually codified into the California Evidence Code, Section 669, and basically it says that negligence is presumed if a plaintiff can establish 4 elements. The first of those elements is, and this is the most important one, that the defendant violated a statute, ordinance, or regulation. So we think back again, let's pivot back to the AVID. California Civil Code requires that we do an AVID on each side, whether we represent buyer or seller, and it's for the buyer's benefit. So if the California Civil Code, which is a statute, it says you're required to do this, and you fail to do it, you satisfy the first element of negligence per se. The second element is the violation proximately caused death or injury to person or property. Now, I want to get away from the death aspect of this and focus on injury to property. So you fail to do your AVID, and there is later damage to the property that continues to get worse after the close of escrow. Third element, the death or injury, and we'll focus on injury, resulted from an occurrence of the nature of which the statute, ordinance, or regulation was designed to prevent. We all know from Easton v. Strasburger that the purpose that we are all required to do our AVID is to help the buyer bring any defects to the buyer's attention while they still have an opportunity to get out of the contract. And finally, the last element, the person suffering the injury to his person or property was one of the class of persons for whose protection the statute, ordinance, or regulation was adopted. This is precisely the reason that the legislature adopted the civil code requiring us to do ABIDs. Now, what is the effect of negligence per se? I spoke a little earlier and said there's 4 elements to a negligence case. There's duty, breach, causation, and damages. If you violate a statute and negligence per se is made applicable, the plaintiff's attorney no longer has to prove that there was a duty or a breach. It happened automatically because of the statute being violated. So what you've done, if you violate a statute and a buyer is harmed or a seller is harmed, because of that violation of the statute, and the statute was designed to protect that party from that type of injury, then the plaintiff no longer has to prove duty and breach. All they have to do is prove that there was causation and that the plaintiff was damaged. It makes their job much, much easier to prove a negligence case. So, real estate example of negligence per se. I'm going to give you guys a fact pattern. Realtor James is representing a buyer in the purchase of 123 Main Street in Sacramento. James and the buyer negotiate a 15-day inspection contingency in the contract, and the contract was ratified on January 1st, 2024. The buyer elects to get a home inspection, roof inspection, and pest inspections. None of the inspections indicate anything of concern to the buyer. So far, so good, right? On Tuesday, January 16th, 2024, which is day 15, based on the cleanup inspections they got, the buyer removes his inspection contingency. Here's some variable facts and how they'll play out. Variable fact number 1, Realtor James completely forgets to do his AVID. Variable fact number 2, Realtor James doesn't do his AVID until January 17th, after the buyer's inspection period expired or after the contingency was removed. Variable fact number 3, Realtor James does a shoddy AVID, I was going to say shitty, I'll say shoddy, a shoddy AVID inspection and misses something that a reasonable real estate professional in James's shoes would have seen as being obviously picked up in their visual inspection to include in an AVID. So now, escrow closes a week later. Buyer and his family move in and they begin experiencing health symptoms that resemble exposure to Stachybotrys mold. The buyer opens the coat closet door at the entry of the home, and this is right at the front door. You open up the door, you hang your closets in there, freely, easy to access, and discovers that the ceiling in the closet is completely black with discoloration. Mold testing confirms Stachybotrys. In addition to medical expenses, the buyer must now move out of the house while mold remediation and repair are completed. A large amount of their personal belongings and property must be removed and destroyed as hazardous waste. California Civil Code, Section 2079 et sequitur, requires that any real estate agent conduct a reasonably competent and diligent visual inspection of reasonably and normally accessible areas of residential properties 1 to 4 units and manufactured homes and condos. Agent inspection limitations only applies to reasonably and normal accessible areas of the property offered for sale. You're not expected to climb on the roof, move furniture, look under furniture, go up chimneys or open up cabinets or anything like that. But when you walk around the house, you are expected to open up closets, open up, coat closets, take a look inside. By the way, on a personal note, I can't tell you how many times I've found that the property had roof issues by looking in the ceilings of a closet. I don't know why, but maybe people don't see them themselves, so they just kind of fester. But on a side note, that is a big deal. So, number one, realtor with the first scenario, Realtor James forgot to do his AVID. That is a violation of statute. That is negligence per se, because the statute was designed to protect the buyer from this type of harm, right? Example number two, Realtor James didn't do his AVID until after the inspection contingency expired or was removed. Well, it's not negligence per se, but likely it is still negligence, because the whole purpose of doing an AVID is to give one more set of professional eyes to the buyer. The buyer doesn't know anything. In many cases, it might be the first time the buyer's ever bought a home. You're a real estate professional. You're licensed by the state. You're supposed to know these things. If you don't know, you're supposed to seek training. And the third example, Realtor James does a shoddy AVID and fails to check the closet or note discoloration. Well, again, it's not, this is assuming he did the AVID and turned it in during his, appropriate period. Not negligence per se, but it is also likely still negligence. The thing you have to realize when it comes to negligence is the cause of action is based on negligence, and there's no knowledge requirement. It's did you or did you not rise to your duty of care? The plaintiff needs only to show that the broker failed to disclose facts that a reasonably competent and diligent inspection would have revealed. And as recently as 2019, that has been the opinion coming out of the California courts. That's the most recent one, I should say. So, any questions on negligence per se? Yes, Leslie.
I just have a quick question on that example. So if the agent had noted in his avid, discoloration or anything like that, would that have covered him then and the brokerage of not being negligent?
No, not well. It would have covered him being negligent under, it would have prevented him from being negligent under negligence per se, under that theory. But in the absence of that agent taking the additional step, and I mean a documented step of recommending to that buyer that they get some sort of lab testing to find out what this is. Yes, then it would be
just based on the discoloration. They should recommend that. Okay.
Yeah. And, just touching on the AVIDs for a second, best practices as a real estate agent, we always, and this is what our compliance crew is going to look at too. You always want to get that AVID done and to the buyer before the buyer's inspection period expires. We have agents that, it boggles my mind, but they're independent contractors, and I've got to kind of hold my tongue a little bit. But it boggles my mind when you have an agent in Sacramento who lives in Sacramento that decides they want to take a listing in San Diego, because I know damn well that agent is not going to be on their timelines in terms of doing things like AVIDs and some of the other due diligence stuff that they will be required to do to sell that property. And speaking of negligence, if there are point of sale requirements that San Diego has that agent isn't aware of because they're not required in Sacramento, and that agent doesn't do them, and it delays a sale or results in, let's just say it delays a sale and the buyer has their moving truck arriving at the house with all their belongings, they have no place to live, and all of a sudden the closing is delayed because the listing agent didn't know that a point of sale sewer line video inspection is required to close. That's negligence on our part, right? Now, there's one more type of negligence I want to discuss, and that's negligent misrepresentation. So examples of negligent or innocent misrepresentation, that might be where you're not sure about whether a property you're listing has a public sewer service or it's on a septic system. So, you told your seller you're going to have it in the MLS tomorrow. And rather than, wait until the morning, it's late at night, you're inputting everything in the MLS, rather than wait until the morning when you can call your seller and ask the question or do some further research, you take the shortcut and you copy a listing from 5 years ago that said where the agent stated that it was on public sewer. It's actually on a septic system. That would be negligent misrepresentation. So just wanted to give an example of that. So let me give you some tips to help you avoid professional negligence. Okay. And the number one, it seems like this should be an obvious one, but it doesn't always appear to happen. Make sure you preserve all of your email and text messages in a transaction. If you don't have something in writing, then it's he said, she said, or she said, or whatever. And when somebody is entering litigation or in litigation with a real estate agent, oftentimes there's public perceptions of the industry, just like with the insurance industry and things like that. If you actually end up in court, you're behind the 8 ball to start with. But if you have it in writing, that can make all the difference. And we've had cases in this office where the detailed written records of the agent they've been the deciding factor in how something played out. So it's really important. Preserve all your emails and text messages. When you have an oral discussion with a client or a third party, send an email that confirms what was discussed and when. You want to professionally document the conversation. I've been doing this for years, but you don't want to be in a position where you're trying to defend yourself later and you're saying, but I told him and he said, okay, let's move forward anyway. If you have it in writing, there's no dispute about what was said. So, Leslie, is my buyer. And, I see something on my AVID and I say to Leslie, you know what? There's some cracks that are, pretty significant on the stucco on the east side of that house. Maybe, be a good idea to get a structural engineer to come out and take a look at it. And Leslie says, oh, hell no, I'm not paying for a structural engineer's report. Well, I say, okay, fine. I'll send you a confirming email when I get back to the office. You get back to the office. Hi, Leslie, just confirming our conversation, so I can have it for my file because, my memory stinks. You decided you do not wish to pursue the structural engineer's report, even though there was some cracks that I thought were a little concerning. Now you have it in your file. Let's see here. Document. Oh, I love this one. Document any lack of cooperation by parties or other agents, including your clients. If you're in this business for any length of time, you're going to come across agents that either don't know what they're doing, they are totally uncooperative. It seems like they're doing everything they can to scuttle a transaction. Make sure you document all those things. Number one, if there ever is any litigation, that might be helpful, might be something that would be persuasive if the thing ever got into court or mediation or arbitration. But number two, you'll have it in your records. So when your client starts thinking, well, maybe you're just not on the ball, you can kind of show your client what's been going on. always a good practice to document cooperation with other parties. Always disclose actual knowledge of any material fact to all parties. Okay. If it's funny, I just got a phone call literally 15 minutes before this class. My former business partner sent me a text. She goes, I have a broker question. Call me. And so, I called her, and the question, it was dealing with a listing she's taking, and it's tenant occupied, and she's out there going through her paperwork, doing her MLS detail sheet and all that stuff. And the tenant says, "Oh, by the way, there was a shooting at a house 4 doors down or something like that about a month ago." Now, that's not something that our agent solicited from her, but now that it's out in the open, um, you know, if you were not to have disclosed that at some point in your transaction when you get under contract, then it could be argued that it was a material fact that somebody that was looking to place their family in a quote unquote safe neighborhood might have passed on this house had they known that, or may not have settled with this house. So, solution in something like that is you want to do what's called a third party disclosure. Something along the lines of, on such and such date and time, tenant occupying such and such resident advised me that, approximately 1 month ago, there was a shooting, on the street, few doors down, blah, 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 signed agent. Just something like that would be tendered over to the buyer side of the transaction. Call it a third party disclosure. Also, under this type of example, actual knowledge of any material fact to the parties. If there was several years ago, when the real estate market crashed in North Natomas, there was a building moratorium that kicked in because all of a sudden FEMA realized their flood maps were off, and they basically stopped granting any building permits. Well, if you knew that there was a potential flood issue and they were going to be remapping the flood zones, that would be something that either the seller or you should probably make sure that all parties are aware of. There was a point in time on Elkhorn Boulevard where they still might be, I don't think they are though, talking about widening Elkhorn and basically taking some of the homes through eminent domain. And so there was a period of time where if you listed a home on Elkhorn, we were making disclosures to the other side stating this is a potential issue that could happen in the years to come. That's what I mean by when you say disclosing actual knowledge of any material fact to the parties, or disclosing all material information to your own client. So if you know something that you think it would be materially important for your buyer to know, you should be disclosing it to them.
Can I ask a dumb question? I don't know if it's a dumb question or not, but
dumb question, I'm sure.
Like, as an example, so like in Elk Grove, they're talking about building that new zoo out there, but it hasn't like really been approved, but there's been like public hearings and da 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 da.
Yeah.
Is that something that should start being disclosed in transactions in that city, or no?
I don't know if I would say, I mean, it's kind of subjective. When you say in the city, probably not. If you're talking about in the radius of an area that's going to be affected by traffic, yeah, probably.
Okay.
Yeah, I mean, another example, might be, I don't know how many of you are familiar with the name Dorothea Puente. You guys recognize that name? She was this sweet little old lady who had a house, I think, in Midtown Sacramento.
I don't think she was very sweet, but okay.
I'm being
Apparently
facetious.
Terry does know of her.
I'm being facetious. um, anyway, she was innocuous looking. She looked like just any average old lady, and she operated a boarding house. And she would take in these guys on Social Security, and then murder them and bury them in her backyard and collect their Social Security checks.
That one, I do know who you're talking about now.
Well, her house has changed hands a few times now. Let's just say, for example, you get a listing, Leslie, of the next door neighbor's house. That would be material information that should be disclosed to any buyer of your neighbor of the neighbor's house, because you have people stopping in front all day long. They want to take pictures of the Dorothea Puente murder house, that sort of thing. It is a notorious home. So that would be something that you would want disclosed. If and this is common sense stuff. If you think something might be important to a potential buyer, using that reasonable objective standard, reasonable agent standard, would this be important to a reasonable buyer who's going to be living in this house? Do you think they would want to know about this?
I have a question about the third party disclosures. If you
Yeah.
hear something about a property from a neighbor, but the seller is trying to omit it, let's say, like damage that's been repaired or something like that. Do you just do the third party disclosure, or do you include that on the original?
Well, what I would typically recommend is, if you hear something from a neighbor, for example,
About the house in question, yeah. Would you?
Yeah, about the house in question, I
Sure.
would first go to the seller and say, do you know anything about this? If the seller knows something about it, it should be included in their disclosures. That way you avoid the third party disclosure. But if the seller says, I've never heard of that before, you should still do a third party disclosure. Okay. Funny you talk about that. Another example on that type of scenario and how it can affect your ability to sell a property. Many years ago in Natomas Park, it's still there. There's a street called Ainger Circle. And there was a time when if somebody wanted to sell a house on Ainger Circle, they called me. And I don't know, in a given year, I probably sold 10 homes on that street. Now, one day, I closed escrow on a house. I represented the seller, and another agent whom I knew represented the buyer. It closes escrow, and the neighbor calls me up. Nice gal. Her kids, my kid, played on the same little league team. So she and I were very friendly. She knew my contact information. She knew who I was, what I did. And she said, hey, I just want to, tongue in cheek, thank you for selling the house next door. I said, tongue in cheek? She goes, I'm really angry. And I said, what's wrong? And she goes, I have 3 kids. You sold it to somebody that's on the Megan's Law list. And I said, I am so sorry. I didn't know that. I didn't represent the buyer. But from that point on, if I represented another seller or another buyer on a property on that street, I would have had to disclose that there is somebody that's on the Megan's Law list that is living on that block. And so for my next 3 transactions, I referred them out to another agent, and I didn't tell the agent why I was referring them out.
So even though it's public record and they get that as part of the NHD report and everything, you still had to legally
Yep.
kind of highlight that fact if you were going to represent it?
Yeah, I would have to highlight it. That's why we don't look at the Megan's Law database.
Right.
Right? The second she told me about it, though, it became my knowledge that I now, without doing any research, I would have had to disclose. And if I'm representing a seller and I have to disclose that, I'm potentially harming the seller. So it was much easier for me just to refer future listings out to other agents, take a referral fee.
Now, if your seller knew, they should have put it in their seller disclosures too, right?
Yeah, and I didn't say anything to the seller.
Right.
Actually, one of the agents that I used to refer those out to is an agent in this office. So, and I never told the agent. All right, moving on. More things that you can do to avoid professional negligence. How about just not giving a legal analysis of it, but reviewing the preliminary title policy with your client, pointing out potential issues that they need to research, talk to the escrow officer about. Remember, you're not lawyers, engineers, surveyors, or anything like that. But if it talks about a utility easement, and when you showed the property and when you did your AVID, you pointed out the telephone pole sitting in the backyard, that's an indication that you might want to point out to your client that the utility company that has the easement to have that pole there also has a right to come into your backyard to maintain that pole and the wires that are on it, right? This is a big one. Give your clients adequate time to review everything that you give them before signing. Do not just send them a DocuSign and expect them to sign it and immediately get back to you. Give them time to review the documents so that they know what they're signing, and let them know if you have questions. Give me a call and we can talk about it. Okay, so often agents just shuffle paper. They'll have their TC send stuff out and say, I need to get this back tonight so I can get this offer over. Give them time to see what they're signing. Okay. And the beauty of you do that on DocuSign, you can actually state right in the message that goes with it, please review these documents. And if you have any questions, please don't hesitate to give me a call or shoot me an email. And that it's all documented permanently for the record. Let's see here. When you complete your AVIDs, make only objective observations. Is there somebody that can tell me what an objective meaning is, what that means?
Yeah, like I see a dark spot, but I don't know what it is.
Sort of.
Like a dark spot on the ceiling.
Yeah.
I don't know what it is.
Yeah.
I just see a spot on the ceiling.
Yeah, or something.
Better
Yeah,
yet.
a discoloration. Discoloration is the word.
Okay, that's perfect. Not saying there is a dark mold looking spot on the ceiling or a dark water stain on the ceiling, something like that. So an objective, just the legal kind of description is that an objective meaning is it's an unbiased, balanced observation based on facts that can be verified. Do not make subjective observations. Subjective would be making assumptions or making interpretations based on personal opinions without any verifiable facts. For example, I had a listing in South Natomas, rat holes in every single room of the house, right above the baseboards or sometimes through the baseboards at floor level. 27 rat holes counted in this house. Now, on my AVID, I did not state rat holes, rodent holes, or anything like that. I described holes in the walls, their approximate locations, approximate diameter and size. That's it. Let's see here. This is another big one, and I get calls about this constantly. Do not personally research zoning issues, permit requirements, HOA rental unit guidelines on behalf of your client. These are things that your client should be researching. We have a potential problem right now with in a case where an investor bought a condo that limited rentals to 25% of the units. And when it closed escrow, prior to the close, our agent contacted the listing agent and said, oh, it's not going to be a problem renting it. Passed that information back to his client. When they were out at the home inspection, the seller told the I'm sorry, the listing agent told the buyer directly, oh, not going to be a problem. Well, it closes escrow and it's a problem because it's well over. The new owner cannot rent the property out. And that's potentially liability on us because we're the one that passed on that information. What should have happened is our agent should have said, you need to contact the HOA management company and review their rental policy. It's also contained in the HOA documents and in the bylaws. So here's those. Make sure you read through them. Take your time to go through those, but then contact the HOA management company to get a final opinion. Likewise, somebody that wants to build on vacant land and they want to build a small apartment or a fiveplex or whatever it is, you should not be telling them that based on its zoning, you can build that. There may be other restrictions you're not aware of. And the second you open your mouth and tell them that information and they rely on that information, because after all, you're the real estate professional, they think that what you're saying is stuff they can rely on. If you're wrong, you've just accepted liability for something that you should have never accepted it for. Right? Oh, do not attempt to make your contract addendums so filled with legalese that you cross over into practicing law without a license. Number one, you don't know or what should or shouldn't be there in order to make it a binding document. And number two, if you are good enough to make it a binding document, you're probably venturing into practicing law without a license. And there's ethical violations there. There's also California state violations there. Try to avoid picking contractors and other tradespeople to do work for your client without researching them with the state to ensure they're properly licensed and carry the appropriate insurance. There's actually a state law now that requires real estate agents who recommend tradespeople, contractors, to validate they have a valid contractor's license and they carry appropriate insurance. If you don't do that, that's now a violation of real estate law.
And workers' comp as well.
Say that again, Riza?
I said workers' comp as well.
That's correct.
Workers' compensation, yeah.
Workers' comp, completion bond, etc. And then try to ensure, this goes hand in hand with that any negotiations that are done directly between your client and the contractor, not you. Try to take yourself out of the picture, because when the work is not done well, you're going to be the blame. When the work, when it closes escrow and the buyer goes after the seller for the shoddy work, the seller is going to believe that it's your fault because they used your contractor. So just be really careful there. Again, we've talked about this previously. Always be insistent with your buyers, if you're on the buy side, that they obtain the appropriate inspections, or at a minimum, sign a written waiver. And that's even if the seller is providing prior inspections they got with a prior deal or pre-listing inspections that the seller did. Doesn't matter where those other inspections came from, you want to recommend that your client get their own inspections. And if they truly, really don't want to, make sure they sign waivers. And don't play this game where they tell you they don't want to. You should still be insistent that it is the right thing for them to do. And I understand you don't want to, but if you're insistent on not paying for these inspections, I need you to sign a waiver for our brokerage. Don't do that presentation with them and say, well, wink, wink, you really don't need to do the inspections, but just so my file's in order, here, sign these waivers. Because that will come back and bite you in the butt if something does come up down the road. Okay, I kind of alluded to this a little before. When you enter a new listing into the MLS, never copy details from a former listings agent to use as your own. because you don't know if they were right or wrong. You should be doing your own MLS detail sheets while you're at the property, so that when you enter them into the MLS, you have all the information in front of you. You know exactly, is there a 220 plug in the laundry room? Is there also gas available? If you don't take a look at that stuff in the property, you're not going to know for sure. If a client or a third party asks you a question that's relevant to the sale or purchase, and you are not, quote, bet your life certain of the answer, don't just guess and make up an answer. And even if you are certain of the answer, consider whether it is a question you should be answering, or whether you should be directing the client to a third party to do their own research. That would be things like zoning and can I build this, and are we in a flood zone? If somebody says, is this a flood zone? Well, you can look in the NHD and you can show them, well, according to this NHD, no, but the other person you want to check with would be your insurance agent. Remember that saying, I am sure you've heard it, never put anything on the internet that you would find embarrassing if it got out in the open. Well, in a real estate transaction, in a real estate sale, with all client and marketing communications, always keep that thought in the back of your mind. You always want to keep this in your head. How would this statement that I'm making now, or the action I am taking or not taking, be viewed by an impartial DRE investigator, judge, or jury? Is there something in what I did that could be construed as not working 100% in my client's best interest? If there is something I'm doing or saying that could be considered a reasonable real estate professional's duty, for example, recommending a home inspection, things like that. Oftentimes, most of our transactions, they go kind of flawlessly. You represent a buyer, you make an offer, you get the contract ratified, you do your inspections and stuff, goes through escrow, the lender's out doing their thing, and eventually you close escrow and everybody's happy. But every now and then, sometimes transactions fall apart. And up until the point where they go south, everybody's nice to each other. They're your best friend. Your client's friending you on Facebook and talking about, oh yeah, you just seem like good people and blah, blah, blah. But when it goes south, that's when it goes south. And you want to keep in mind that although things are good now, if it does go south, people will review this transaction in the light of everything that's been said and done up until now. So just remember that in the back of your mind before you send that text message out, or before you do this or that, or, before you decide, you're going to dual representation is not a problem in this transaction. Just remember, you do dual representation. There's certain things you can no longer say to this side, and from this side, there's certain things you can no longer tell that side. And if you do so, especially you put it in writing, it becomes part of the permanent record. And that's the kind of thing that can come back at you if everything goes south. All right, moving on. I want to talk about some of the top legal claims that we see against real estate agents. The big one is real estate fraud. This comes from what I like to call commission breath. Somebody is, dealing from a position of not having a lot of stuff in escrow. They're living rent check or mortgage payment to mortgage payment, and they will do anything to get a deal to close. And unfortunately, that person's character does not put their client first. And that results in fraud. So fraud in a real estate transaction can occur in any phase of the transaction. And this is not just real estate agents. It can be mortgage professionals in the mortgage application, or the approval process of the mortgage, or through the closing of the sale, or anything involving the purchase of real property. some of the things we see are like falsifying or encouraging falsification of a loan application. Realtors that doctor or prepare fake pre-approval letters. That's actually a real thing. I can tell you, I personally have received counterfeit Wells Fargo Bank pre-approval letters. And I reported them to DRE. And the funny thing is, it probably wouldn't have come to light, except when I was a listing agent. If I got a pre-approval, I wanted to talk to the loan officer to make sure they really believed this buyer could close escrow. And so I would call the lender on that document, and all of a sudden you start getting these, I've never heard of that person. Well, the agent is so-and-so, and, it's this pre-approval letter was addressed to you and the buyer, or to the agent and the buyer, from you. No, it's not mine. And so this kind of thing does happen.
Can I share something with that, Bruce?
What was that?
Can I share something along that same
Yeah.
line? I've actually received fake proof of funds before. I know it's weird, but like the digits were a little off, like between the balance and their transactions, and then the name, like it was like tilted. So as agents, yes, we have some due diligence. We have to like make sure the stuff we're collecting is decent, and we can't verify it is 1,000%. But this was so obvious when that agent sent it to me. I'm like, could you resend an updated one? And then I compared them, and they were so fake.
Yeah. Well, I mean, the thing is, Leslie, if you get a document like that, and there is like, let's call it a red flag, something in that document just doesn't look quite right. Let me ask you then, if you see that, do you think you can argue that it then becomes part of your duty of care that you owe your client to verify that it's real?
Yeah.
I would argue if you see a red flag that, it does become part of that duty of care.
Do you avoid that by just reaching out to the lender directly once you have a listing or you're accepting offers, excuse me?
Well, I always try to reach out to the lender for a buyer before.
Just to avoid any of these issues, like just for every transaction, it would be probably the best.
I always like to talk to the lender before I accepted an offer.
Yeah, I do too.
Okay, sounds good.
Sometimes they would not have seen that same proof of funds. They might have a different bank account that they're verifying. So I still think you would, if something, like Bruce said, if something was a red flag and we ignored it and then it came back later, it could be challenged that we didn't provide our fiduciary responsibility to that client.
And that could be negligence as well.
Yeah.
We actually had a case of an agent in our office who was doing something not under our KW license. They were doing this thing where he was being paid a fee to place rental tenants for property owners who were renting their properties out. And that's not something and we weren't aware that the agent was doing this. But I got a call from a broker in Southern California, and the broker said, "Hey, I just want to make you aware, you have an agent in your office. He's trying to place tenants with properties that I'm renting out. And over a period of 6 months ago, I got an application with a credit report. And I just got another application for an entirely different person with a credit report. And the two credit reports were identical, except the names were changed. And these were done, it was clear this agent was doing this stuff. Now, this is actually civil fraud. It's also criminal fraud. And so I terminated the agent, and I reported the agent to the Department of Real Estate. Took a year and a half, but now there is actually an accusation on his license. They will be revoking his license. And I'd be surprised if they didn't refer him to the district attorney's fraud unit. But anyway, that's the kind of stuff that goes on out there. And that's what us honest agents have to be prepared to deal with. So you have to think about, well, yeah, agents do this stuff. It doesn't mean you have to be paranoid all the time. But if, like Leslie says, you see something on a pre-approval or a proof of funds, and that one little item gives you a red flag, yeah, maybe do a little deeper dive on it. Moving on here. Representing, and this is something that really, especially when you getting into a market, and we may have a market coming up where we start seeing more foreclosed properties, but typically, and you may or may not know this, most government entities that hold foreclosure properties like HUD or Fannie Mae, some of the private companies as well, most of them have policies that they have what's called an exclusion period. When a property is first listed, it is only available to buy if you are an owner occupant or a registered nonprofit or government entity. And they exclude any investors from having access to buy that property, usually for 30 or 45 days. If it hasn't sold within 30 or 45 days, then they open it up to everybody. Well, if you're representing a buyer and you know that that buyer has 25 investment properties all over the city, and they're telling you that they're buying this to occupy, and it's the worst house in the hood of the city, and it seems implausible to you that that they're buying this property to live in, you're probably right. And you need to think about whether this investor is actually falsely representing themselves as an owner occupant and whether you want to participate in this. Because if it could be argued later that you were aware that this person was falsely stating that they're going to be an owner occupant, you could be involved in a crime. And that's one of those things that could potentially cost you your license or a sanction on your license. Let's see here. Moving on. Real estate examples of fraud. My real estate agent knew there was a discrepancy regarding the square footage of the home, and he purposefully did not disclose to us, meaning the buyers. That would be fraud. Number two, the listing agent had actual knowledge that there was a well on the property that did not produce the amount of water that she had represented in the MLS, or the water level was so far below what was acceptable. There was not enough water to continue to let that property operate normally. The agent knew that, but failed to disclose it. That could be potential fraud. Other things that agents get into trouble for. Breach of fiduciary duties is a big one, and that usually goes hand in hand with many of the other ones, including negligence. Real estate agents owe a fiduciary duty to their clients. Pardon me, this stuff is so
Boring
boring.
yourself, Bruce?
Oh, yeah. They owe a fiduciary duty to their clients, the most important aspect of which would be the need to operate honestly and in the best interest of the client. So in general, when a real estate agent decides to act for their own personal benefit, we talked about commission breath, to the detriment of their client, they've breached that fiduciary duty. Real estate agents spend most of the property purchasing process working independently of their clients. They negotiate with other parties, they coordinate inspections, they review contract documents. So an example of a fiduciary breach might be obtaining covert fees or profits that are not revealed to the client, i.e. they're an undisclosed principal. Or failing to notify a seller that there were other offers that were made after the offer was accepted, or declining or accepting an offer without the client's consent. Any of these could be a breach of fiduciary duty. And I know, again, if you fail to submit an offer to a client, especially if you are pushing the offer that you happen to be double ending, if that comes to light and DRE gets involved, somebody makes a complaint, I guarantee you, you're getting your license revoked. Contract violations. A real estate contract is obviously a document that contains terms and conditions of the real estate transactions. And they're integral to a real estate transaction because under real estate law, they have to be in writing under the statute of frauds. Because the types of contracts involve the transfer of real property, if the listing agent fails to do, for example, like on a listing, fails to do the marketing that they claimed they were going to do when they listed the property, that could be a contract violation, affording the seller rights of rescission or other things, depending on what they can prove. If the agent represented that they're going to do placement, they're going to send out X number of postcards in the surrounding area, they're going to knock on doors, they're going to do all sorts of stuff, and they fail to do that, and maybe they delayed getting it in the MLS for a little bit because they were enjoying their week's, Arctic cruise, and they wanted to wait until they were back, or whatever. And the property got delayed getting on the market, and then the marketing was substandard based on what the agent represented they were going to do. And the guy ended up losing money because the property kept dropping down in value because it wasn't getting good exposure. Or he only took one photo of the front of the house instead of showing what it really looked like, which of course would have enhanced the placement on realtor.com and how many, all that good stuff that goes with the social media marketing. You could argue that the agent violated their listing contract, violated their terms of their listing contract. And if that happens and the seller is harmed, the seller may have remedies there. Negligence we talked about, but in the respect of what would a reasonable real estate agent have done under similar circumstances. Client can claim that their real estate agent knew or should have known a fact or issue, but failed to take any action in order to prevent or address it. Running a little bit behind here. Misrepresenting property conditions, damage, or value. This is a big one that hits agents a lot. Although the seller or buyer is ultimately responsible for disclosing any property defects that are involved in a real estate sale, real estate agents also have a responsibility to disclose anything that materially affects the property. This means they must disclose relevant facts if the value or desirability of the property would be negatively impacted. I.e., listing agent orders a pre-listing roof report that discloses the roof is at its end of useful life and can't be repaired. Agent buries the report from not only the future buyers, but from his own seller client. Or misrepresentation regarding flooding or leaks in the property. Disputes associated with escrow and down payments. This is, more common than you think in the context of the example I'm going to give you. But if you're representing a seller and you negotiate a contract, the seller's got 3 days to get their earnest money deposit to escrow. If you're doing your job, if you're exercising the duty that you owe to your seller client, you should be making sure that that EMD is receipted in at the escrow company in 3 days. If it's not, you should be, jumping on that buyer's agent like white on rice, and keeping your seller informed as to what you're doing as well. I can't tell you how many times I have seen agents, they'll make it 3 weeks, 4 weeks into a transaction before they finally discover that the EMD never made it there. They're reviewing the final settlement statement, making sure everything's right, and it's not having any reference to an EMD received. And that's when they finally realize, oh, gee, the buyer never got their EMD to title. That should never happen. All right. I think that is probably all the stuff I wanted to cover with this. I am open to questions, anything, everything, fire away if you have them. I got nothing.
I would say, what's the most common one you're seeing like in our office right now that's kind of like the hot button?
It is still getting ABIDs done
Yeah.
in a timely fashion.
Guilty.
Yeah, especially you being a coach, that should never happen.
I know, I'm working on that, Bruce. I'm working on
Okay.
it. They're not fun. I'll just be honest. They're one of those like necessary evils, but they are so important. And I just had an example of why they're important. I actually did my one for my listing on time. I did it when I took the listing and everything. And it really came down to a he said, she said thing when we got a repair request. They wanted $5,000 for carpet replacement because they said they smelled dog urine. And a ton of people had been in there. Nobody smelled it. They were just trying to get more money.
Yeah.
And I was like, well, I pointed back to the agent. I'm like, that's interesting. There wasn't anything on your Avid that mentioned this when you came through. There wasn't anything in any of the emails, text messages, every time you've been at the home. So the documentation really helped to support that.
Yeah, absolutely. And let me offer this as well on the ABIDs. And this is what I always did. And this is, I think a good way to handle it. My practice, my personal practice, I did, a couple thousand listings over my years. Not all of them since the days when you actually had to do an ABID. It used to be in the old days before the ABID, you had.
And for those of you that don't know, the ABID is Agent Visual Inspection Disclosure.
Thank you,
in case
Leslie.
you haven't done one yet. Yeah.
But it used to be, instead of having these pages where you could write all this stuff, on the third page of the TDS, and they're still there, it had like 3 little lines where the agent could make all of their observations as to what they saw in the house. The release by CAR of this ABID form made our lives so much easier because it actually breaks the house down by bedrooms and bathrooms and exterior and whatnot. So it makes it much more difficult to miss going into a part of the house. I will confess, even in the last 3 years ago, I did an ABID on one of my listings and I forgot to go into the garage. I had to go back to the house and look inside the garage. So even though it breaks all that stuff down, you can still forget.
Yeah.
But the form itself makes it much easier.
It does.
Yeah.
So with the ABIDs, what if I've noticed something and the inspector does his report and what I noted, like a discoloration somewhere, the inspector doesn't know? Is it something to just leave alone or should I reach out to them or how would you handle that?
So
like I did a visual check and maybe they got a phone call, same thing, and they forgot to check a room or who knows what happened.
No, as long as you are not getting feedback from the home inspector at the time you are doing your ABID. Because you notice on the top of the second page, I think, it actually has a spot to put the date, time, and who.
No, I'm saying 2 separate reports. There's something on my report that I saw that the home inspector didn't address.
And the home inspector missed it.
Yeah. So
yeah.
would I?
No, you don't need to go back. You don't need to go back to the home inspector or anything like that. What you just talked about, though, this is the exact reason that those court cases and the state wants us to do that ABID.
Yeah.
Because you, in your professional capacity, you found something that the home inspector missed. You are that extra set of eyes to protect that buyer. Okay. So what I recommend you do, if you're on the listing side, do your ABID at the same time you do your listing paperwork out at the house. It makes it easy. You just knock it off right then and there. In my practice, and I'm old school maybe, not as technologically savvy as some of you might be, I would do my listing presentation, and then if I got my listing, which I usually did, I do the listing paperwork. I would do while the sellers were filling out their TDS and their SPQ, I would be going around the house doing my ABID and filling out my MLS, my Metro List listing detail sheet. And then by the time I left that house, I had everything except the photography done.
It's a good question about that. So
yeah.
How long would you say our AVIDs are good for before we should redo them? Like, let's say we're taking a listing, we're getting stuff ready, not going on the market for like 30 or 45 more days. Should we redo it when we hit the market or just use the original one? What's your,
I don't know that there's any case law on that, and I don't know if anybody's actually come out with a regulation on it. I don't think they have. But I would say, what's reasonable? If it goes more than 90 days, there
okay,
might be more dings in the walls. There might, I would say update it in 90 days.
okay,
I don't think there's any hard or fast rule.
okay.
I do want to say, though, that's the easiest way to get your AVID done
Yeah,
on the listing side, because then you have the seller sign it before you ever leave. And when you get the property in the MLS, you walk away from the house. Hopefully, you're going to have your TDS, your SPQ, and your AVID. If the seller needs more time to complete the TDS and the SPQ, it might be a couple more days. You'll be able to get that. You'll have all of that stuff ready by the time you actually get a buyer and you're under contract. You can get all those disclosures over to the buyer side right away. There's no delay. That way you have fulfilled your duty on the listing side. If you're on the buyer side, typically, as I said, you want to encourage your client to do a home inspection. You cannot just go out to the house and open the door for the home inspector and let them roam around on their own free will. You have to be out at the house with them while they're doing the inspection. What better time? It's early in the transaction. You're not going to wait until, a few days before you're going to close, before you're going to do your home inspection. You're going to order that inspection right away once you get under contract. You go out to the house, you let the home inspector in, and it's going to take a couple hours. Why not take your AVID form with you? Do your AVID while the inspector is doing their thing. You don't want to talk to the inspector about what they're seeing. You just want to do your own thing. And then in my case, I used to have the buyers meet me out at the house 20, 30 minutes before the home inspector was done. He could kind of download the high points of the inspection with them. And once they were finished, I said, hey, by the way, here's my agent visual inspection disclosure. I give them a minute to go through it, ask any questions or whatever. I have them sign it right there. Done and done. Then I just send it over to the listing side, get the agent to sign it. If the agent or the seller refuse to sign it, I'll have documentation. I made a diligent effort to get them to sign it. But the most important signature on there, aside from your own, is the buyer's. And that's no matter what side of the transaction you're on. But it makes it really easy to get these things done early on in the transaction during the buyer's inspection period. And that's the important thing.
So, Bruce, how many people are signing the Avid? Obviously, after it's completed, it's
the buyers and the agents. And I think there's a spot for the seller to initial, although they may have just removed that.
It wasn't, the seller initial wasn't required on the Avid, but it's encouraged.
Yeah,
They're
they
not.
might on the newer version. I think they might have removed that.
Did they remove it?
Yeah, maybe.
So this might be a question because I'm new. When you do the AVID for a listing, let's say, and then you see something significant that wasn't on the disclosure, would you ask the seller right then and there, or?
Yeah, well,
like say, hey,
if you're out at the house and
what
you
happened
just
here in the
finished your
bathroom?
AVID,
You didn't say anything, yeah. And then I noticed, there's like swollen floorboards or something.
Yeah, I mean, you could mention to the seller, hey, you don't want to do the disclosures for the seller. You never want it to be your hand moving that pen. It should be all the sellers doing that. But you can say to the seller, I did notice this thing. You might want to make note of it on your disclosures. Anything else?
Yeah, Bruce, for condos with homeowner association, I had on Sunday, I signed a contract, my first ever deal, and for a listing, and there
are what?
A shared laundry room and a shared garage, and obviously for condos, I mean, this particular one, the homeowner association will take care of all the exterior, right, all the repairs and everything. You still do all of the inside, outside, shared garage, laundry, Avid, correct?
I would do it just to be safe.
All right. Awesome. Thanks.
Okay. Anything else, guys?
I think that's it.
Thank
you.
Well, I appreciate you guys attending.
Look at that, Bruce, 9 minutes early.
Oh, look at that. If you guys have any constructive feedback, good or bad, I've got broad shoulders. Please shoot it to me. I'd love to hear it. Hope you learned something. Was it beneficial, do you think?
I
It
know
was
what
amazing.
paddles are.
Okay, all right. Well,
Just sometimes
I'm glad the six of you got to enjoy it.
it was great, and it's good to be reminded all of this. It's great.
Yeah, I mean, the overall thing is just think about what you're doing and how it might look to an outsider after the fact.
I always say if I can sit in court and I can stand behind my document, I'm good.
Yeah. Well, and that's very true. You know, so much of litigation can be avoided if agents just act morally, act justly, treat others like they would like to be treated,
Yep.
and try to
It's not that hard.
represent their client in good faith and do what's best for the client. And if you remember those things, that'll knock off 90% of any risk that you could ever be involved in. So,
Appreciate it.
all right.
Thank you. Great day.
Have a good afternoon, guys.
Thanks, you too. Bye.
Bye.
Thank you.